SJC-11667, Commonwealth versus Tamik, Kirkland.
Okay, Attorney Schnipper, whenever you're ready.
Good morning, Chief Justice Budd, and may it please the court. I'm Merritt Schnipper here today on behalf of the defendant Tamik Kirkland. As a practical matter, the post-conviction evidence we introduced establishes beyond meaningful dispute the defendant did not have and could not have had cornrow braids in his hair on the date of these offenses. That means that he lacked the signature trait that Darrell King attributed to the barbershop shooter. Just as significantly, it means that 3 Commonwealth witnesses testified to what we now know is an impossible fact.
Yeah, but can you help me out as far as the evidence on the barbershop, the corner? Because I thought the evidence was that the assailant had the hoodie up.
Right, so the evidence was that he...
Take me through that.
Sure,
as far
so
as
Darrell
when
King,
the hoodie's up and down and the like.
Darrell King testified that the assailant kind of backed in with the hood up on his head, turned around and began shooting at him. The hood apparently had ridden back sort of to the mid-head point so that he could see the braids on the front of the person's head. And then, of course, the firing ensued. He went down and then the shooter fled. So basically, you know, the post-conviction evidence that we put together in the form of expert testimony from Joy Talbot, the member of the Barbering Registration Board, and her viewing of the booking photographs that were introduced at trial, and her testimony that the hair as shown in those booking photographs was too short for the defendant's hair to have been cornrowed, combined with the fact that he, of course, was taken into custody at 46 Burr Street, which is the location in which 3 witnesses claimed he did have the cornrows, that they all said they saw those cornrows, including 2 police officers. And he, of course, is in custody at all times until those photographs are taken. So simply with expert testimony like that was provided by Ms. Talbot at the post-conviction hearing, and the booking photographs that were already introduced as part of the defendant's case, I think that powerfully indicates that he could not have had the signature attribute that King described on his assailant.
Counsel, could I push back on that for a second? Because you keep saying it was a signature trait, right? But wasn't he unequivocal in his testimony that he didn't rely on the hair to make the identification, that it was once, like you just described, when the hood came backwards, that he saw facial features of the shooter, and that was what he used to identify the defendant as the shooter?
Certainly guided by the prosecutor, primarily at the suppression hearing, but also later at the trial. He did agree with the prosecutor, yes, I looked at his eyes, I looked at his cheekbones, I looked at his ears, these types of things. So he did disclaim reliance on the braids. Of course, when he first discusses looking at the array, he says, I noticed that he had braids just like me, and obviously like the shooter. And of course, one of the issues that I'm raising in my brief is how much, given the current state of understanding of eyewitness identification science, we can really rely just on the overt statement from a witness, well, this is what I relied on, this is what I didn't rely on. And of course, in combination with the post-conviction evidence we presented from Joy Talbot, we also brought in, a very sort of detailed and exhaustive testimony from an eyewitness identification expert who explained not only all the things that were wrong with the procedure and the observation conditions that happened in this case, but I would argue most significantly, the way that King's limited prior familiarity with the defendant, both from around the neighborhood familiarity and then to exposure to his photograph, which also showed him with cornrowed braids following his escape from prison and the time he was at large, that all that is very strongly, arguably, the source of his recognition of the defendant as the barbershop shooter. Dr. Quinlivan explained in, I think, very significant and extensive detail how King talked about how a person came up to him a few days before at the barbershop, talked about mamas and papas getting shot. King immediately turned around, calls his son, said, I hope you don't have anything to do with this woman getting shot. And then when he's in the hospital being interviewed by the state troopers, the very first thing he says is, I'm in here shot up because of my son's activities in the street. As Dr. Quinlivan explains, you can tell he's drawing a direct line between the anticipatory fears that he had in relation to both the incident that happened at the barbershop with the fellow who approached him, his viewing of the pre-incident publicity around Kirkland's escape, and then, of course, the process of transference by which a person who basically has a set of expectations in their mind and a set of concerns in their mind, fears of retributive violence in their mind, how that combines with the fact that he barely had an opportunity to see this individual at all, that he was under extremely stressed out conditions that reduce identification accuracy in the range of 30 to 40%. He's got a viewing time she puts at 29% accuracy rate based on an under 12-second viewing opportunity. So all these factors. Then you've got, as she describes, the process of elimination that he uses, where he's sorting through the photographs. He goes from 8 to 4 to 2, finally to 1. Dr. Quinlivan explains how prior familiarity and poor viewing conditions would combine to affect what she calls relative judgment in that type of circumstance.
Can I ask you about the elephant in the room?
Sure.
The firearms.
Yes. So you mean the one that he has in his hand and the one that's in the
Yeah.
house? Right. So obviously, we're not in any way suggesting that there's not significant circumstantial evidence of the defendant's involvement in the crimes. But I think you have to look at that elephant as well as the sort of other elephants, the sweatshirt with DNA on it and stuff, and you have to view them in the context of the way the third-party culprit defense played out in this case. Because it's interesting, isn't it, that in the Commonwealth's opening, there's no mention of a third-party culprit, there's no mentioning of another actor involved. By the time the closing of the Commonwealth's case happens, the prosecutor says to the jury, well, obviously this guy, Trevin Smith, has to be involved in some way. We know that, but he's not the barbershop shooter for these reasons. But if you look at the case in its entirety and
Before
the theory,
you leave the entirety, I want to go to 24 on your brief for a second, because I got confused by your description of the guns for a second.
Okay.
So, State Trooper Crane testified to gathering discharge cartridge casings from both Browns and 46 Spur. Crane opined that 15 cases from Browns were discharged by the Ruger, 4 were found there were discharged by the Taurus, and the Ruger fired 2 bullets recovered from innocent's body. Okay, so obviously both guns are firing at Browns, right?
correct.
I don't understand the last sentence you write. He could not opine on whether the Taurus fired any bullets or projectile fragments recovered from the barbershop. What do you mean by that?
What I just mean is that he was able to connect cartridge casing evidence from both guns to the barbershop, but only projectile evidence from the Ruger that was found at the house. And the implication there is simply that the gun that was found in Kirkland's hand, there was no ballistic, no projectiles.
So the guns used, both guns are at both places, right? Both guns are being fired at the barbershop.
Correct.
The second gun, one of the guns is recovered on your client. The
That's the
second
Taurus,
gun
yes.
is brought into the house, right? There's
It's found in the house.
Found in the house, and we've got testimony, is her name Campbell? I can't remember her name.
There's LaKiana Carter and Carolyn Wright are the 2 witnesses at the house.
Okay, so, and the woman who's getting her hair cut
That's
says
Carolyn Wright.
he comes in and brings in and drops the gun on the couch, right?
No, LaKiana Carter is the one who says he puts the gun in the easy chair.
Okay, so he puts the gun in the easy chair. Is she also the one who watches? She watches him. She identifies he has cornrows, right?
No, Carolyn Wright is the one who says he has cornrows. She says she identifies him by a side array that shows he has cornrows that, as I'm arguing, he could not have had.
Right.
So,
Oh, I thought you were arguing that he's a different guy.
well, what I'm arguing is that there's a strong third-party culprit defense based on the idea that Kirkland is hiding out at 46 Burr Street because he's on the run from the police after his escape from prison, and that this fellow Trevin Smith, who's the third-party culprit, who all 3 civilian witnesses at the house lied about his presence there that morning, and that the third-party culprit defense is around the idea that he's the one who went down the barbershop, committed the shooting, ran back up to the house, dropped all his stuff, and took off to God knows where.
Doesn't the sweatshirt have your client's DNA on it?
The sweatshirt had his DNA on it, yes, it did. But, all that means is that, the whole idea that he has to be somehow associated with Smith really cuts both ways, right? So if he and Smith are trading off clothing or part of the same group or whatever, but if Smith's going to go do this crime, there is no evidence to suggest any sort of joint venture liability between the 2 of them about this crime. And of course, there's no instruction to the jury about joint venture liability. This is a case that's tried exclusively on the theory that Kirkland's the shooter.
The gloves, we can assume that are near the Ruger have your client's DNA and gunshot residue on them as well, right?
The Ruger does not have any DNA.
No, the gloves.
The gloves have that, yes, that's established at trial. So it's certainly established at trial that he's been in contact with this clothing that has his DNA on it.
So under the Commonwealth's theory, the shooter would have to have 2 guns.
Well, the shooter, we certainly, the evidence is that the shooter had 2 guns. And so the third-party culprit theory is that at the time, that after the third-party culprit comes back to the house and abandons his stuff, that Kirkland, who's trying to make his escape, grabs one of the guns and takes off to defend himself as he's making his escape.
Oh, and then goes into the trunk with the gun that the shooter had carried, with one of the guns. The shooter
That's,
had carried.
yes, that's right. And of course, and I think it's, eminently reasonable to believe that if a shooter commits a crime and runs to the house where you're hiding out because you're on the run after escaping from prison, that you would then try to get away under the understanding that the police are going to be following that individual to the house where you're hiding out.
But how does it fit that the gloves have your client's DNA on it, if that's the scenario?
Well, it's just that there's stuff that he's been
There's a
wearing around
discard-
his house.
that you have to have someone discard the inculpatory evidence, the gloves and the sweatshirt in the house,
That's right.
that being your client.
Well, I mean, the theory behind that aspect of things is that the fact that that has that stuff on it doesn't mean that he was the shooter. It simply means that he's got stuff that has his distinguishing marks on it that is quite similar to what the shooter was wearing.
With gunshot residue.
That's right.
Okay.
But, I mean, I think this is why you have to get right to the nut of the case, which is like, well, then what on earth is going on with this testimony that he could have had cornrowed braids when we know it was impossible for him to have cornrowed braids? So why, and I would just like focus the court on the rebuttal evidence presented by Springfield Officer Patricia Capozza, who's not on the Commonwealth's witness list, who's simply brought in as a rebuttal witness solely for the purpose of coming to the court and testifying that she rode in a prisoner transport to the hospital with him, sat next to him for 20 minutes, 3 feet away from him on the ride from 46 Burr Street. She observed tight to the head cornrowed braids.
And can you tell us how that played out at trial as opposed to post-conviction? Because there's an argument about how much it was played up that defense counsel and for tactical reasons
Sure, well, I mean,
didn't get into the cornrow
after
issue.
Patricia Capozza gives that testimony, which, is supposedly from her, just personal memory from 2 years ago with no report written or anything. She just shows up, that's burned in my memory, that guy had cornrowed braids. The defendant at that point refuses to come out for trial. He's so upset, he wants to introduce additional evidence that could have proved he didn't have braids on that day and couldn't have had braids on that day. And he says that that establishes not only his innocence of the shootings, but the false testimony by 3 witnesses. Obviously, counsel reads into the record a very lengthy statement by the defendant about his objection, but says, we as experienced defense lawyers have decided not to go this route. The defendant wants to introduce a photograph of himself with a woman named Chelsea Blake taken at Shirley minimum, right before he escapes, to establish just how short his hair was 8 days before the crimes. Counsel says we decided not to call her because we're concerned about the Pandora's box that her testimony might open. But of course, at the new trial hearing, counsel concedes we never reached out to her and spoke to her. We had no idea what she might say.
What did, I think I saw a blurry photograph of it perhaps, but what did the booking photograph show?
The booking photograph of the defendant showed him sitting, it sort of was a profile and straight on. It showed him, he was in a hospital Johnny and some kind of bloodied gauze around him, but with hair that's kind of like a little puffy on top, quite short on the sides, and not braided. And when Joy Talbot, the expert, takes a look at it, she looks at all 3 sets of photographs, but those ones, which were already in the trial record, she says, this is the clearest example of no, this hair could not have been braided.
But the defense attorney had that information. Of course, he had the booking photograph.
Yes, he introduced it as part of the defense case.
Right, saying that the
But what he
description of
did
the
not-
shooters with cornrows, here's the booking photograph. He
didn't
certainly
have
didn't
cornrows.
get his hair styled in between the
Right,
shootings.
that's exactly what he says. So what does the prosecutor, who very ably handles this case, argue? He says, well, nobody knows what happens in the 6 days between the time he's captured and the time these photographs were taken. What we know is that hairstyles can change. You can have braids, your braids can go in and your braids can go out.
I missed that, I'm sorry. So there was a delay in the booking because he was hospitalized.
That's right.
Okay.
But of course, under significant guard, given the status of the offenses.
But
he was
weren't there also photographs taken while he was in the hospital that were introduced?
Yes, those were the day after. That was kind of stills from a video that was taken by which of course also showed him, 2 things that I think are relevant there. The first is that they were not of great quality. The trial judge denied the defense request to introduce an enhanced version of that video that a company had produced. She felt it would just have been cumulative. But of course, the government argued that you couldn't quite tell. It looked in those photos as though he had braids, and then, okay, now he doesn't, but we don't know what happened in those 6 days. But the point is that nothing that could have happened in those 6 days was relevant to whether he could have had cornrows in his hair, because his hair was too short 6 days later, which just means it was 1/10 of an inch shorter on the days of the crimes. This is what Joy Talbot testified to. Hair grows at 1/2 an inch a month as just a matter of biological fact.
Could I press you on Ms. Talbot for a second? Because one of the things that struck me about her testimony
This is Talbot, I'm sorry.
Ms. Talbot, yeah. So if I understand the motion judge's rationale, the infirmity with her testimony is you can't establish what it looked like beforehand to have some measure of whether or not you could cornrow that hair. But one of the foundational requirements for admissibility is that it will be helpful to assist the trier of fact. And she testifies to something that I hope that maybe you could help me understand. She testifies at her hearing, at the, motion to suppress. I believe that I just want to make sure I have it right. Oh, here it is. And you questioned her at the motion for new trial? On page 24 to 25 of the transcript, you ask, is there a sort of minimum length at which a person's hair would have to grow to be cornrowed? And she responds, any layman could tell you that you need enough hair to grab a hold of and pull. Doesn't that necessarily mean that we don't need her testimony? If she's saying herself that any layperson could look at someone to tell whether or not the hair is long enough to be cornrowed.
I frankly think that that's attributing a little bit too much to her use of the word layperson. What she basically means is that everybody understands, or this is what I would believe she was saying, that everybody understands that you need to be able to hold onto hair to braid it, right? But what we're talking about here is a specialized style of hair that's not just braided, it's, tightly.
Cornrows, that's what you used.
That's
You said cornrow.
Oh, yes, no, and that's what I
that-
was asking her
right.
about. So the fact is that you can't necessarily tell, I don't think, just by looking at one photo, whether the hair can be taken in hand and stretched out enough to braid. That's the first question. I certainly didn't intuit that, and I frankly don't think trial counsel understood that because they hadn't spoken to someone with the relevant knowledge. But the more important fact is that you have the government getting up and arguing something that had testimony like hers been introduced at trial, that would have just rebutted what he makes as kind of like a common sense type of argument. Well, nobody knows what happened in these 6 days, but the defense could have said, it doesn't really matter what happened in those 6 days. It's not about your layperson's take on, well, people can change their hairstyle. We all know that. The question is, could this person have had tight to the head cornrowed braids on one date and 6 days later not? And it's not simply that the hair was too short. It's that she had said if cornrows are removed, there's going to be signature grooves and markings and plates where the hair was parted. If extensions meant to simulate them were cut out, there'd be patches and a pile of waste product. I don't think either of those are within the common knowledge of the jury. And what's really important here, I think, is that you've got a case that's powerfully circumstantial against the defendant, and you need more than simply cross-examining the witnesses in order to mount the most effective defense. And what you've got is a defense that's predicated on two things, challenging King's identification and the defendant could not have cornrows. And there was easily available expert testimony to really substantiate the aspect of couldn't have had cornrows.
Can I interrupt you there so that you can maybe focus on that a little bit more in context of the case that you emailed us from the U.S. District Court, Ayala? How would all this interact in our consideration of the case today?
Sure, but I think obviously, so Ayala is a case that this court decided, and among the things the court decided was that counsel there was not ineffective for not getting an identification expert here. That's not the issue that I cited the habeas decision for. The habeas decision discusses the fact this court said, well, it was completely reasonable instead of getting an identification expert in that case to cross-examine the eyewitness based on his mental health problems and all the psychological troubles he had had and how they might have related to his perceptive capacities on the day of the crime. What the habeas court said, which, by the way, the habeas judge was the prosecutor in this case, what the habeas court said, Judge Mastriani,
Okay.
he prosecuted this case when he was the Hampton DA.
Oh, okay. I just got, never mind. Got
This
a
is
little mixed
that
up there
long
for a
ago.
minute.
But so basically, what he said is, yes, counsel was ineffective because that was a coherent strategy, just like this court said. But if you're going to follow that strategy for challenging the ID, you have to go all the way. You have to actually get the psychological records that would show truly the depth of perceptive issues that were established by the defendant's psychological problems. And when those records were obtained, it showed that the eyewitness had been having hallucinations that actually bore a strange similarity to the events he claimed to witness in the Ayala case.
This case is a garden variety pre-Gomes case, correct?
Well, it does happen pre-Gomes. I wouldn't call it garden variety.
No, but as far as focus on the weapon, all the factors that we've talked about, but there are lots of cases we've had.
Sure, we're
that-
not trying to
right.
retroactively apply Gomes. What we're really trying to say is that under the analysis this court advanced in Commonwealth versus Epps, it's well established by the issuance of the study group report a month after the trial in this case, that there was substantial science that could have been the foundation of a defense based on eyewitness ID at that time. In the time since the trial, the utility of such science is only strengthened in cases like this, such that if the trial were tried even a few years later, it would have been manifestly unreasonable not to get an ID expert. In that context,
But we've had many cases involving a failure to use an ID, a pre-Gomes case, failure to use identification expert.
you have. I would urge you to take a look at the specific facts of this case, because it's not just about the Gomes factors. It's about the way that familiarity plays a role in this identification that's completely contrary to the way this court talked about the role of familiarity in Commonwealth versus Thomas. This is a case in which familiarity creates a risk of mistaken identification, does not make up for bad procedures or poor viewing opportunity. It's a case in which, I haven't found any case discussed by this court, in which a person's individual preconceptions about a person and what they might do can be read to have informed the nature of an identification made under very poor circumstances. I think that's why Dr. Quinlivan, this is not simply a case, because there's almost every identification case, there's some utility an expert could have provided. Right. But this is a case in which the evidence is more or less a checklist of things that not only an expert could have effectively addressed, but that there's really no other way to understand how this could be a mistaken identification except with the aid of an expert, because everything that she's talking about is completely counterintuitive. Familiarity isn't a balm for bad procedures. It increases the risk. The prosecutor in his closing argument says, Darrell King started with 8, sorted to 4, went down to 2. How else would you want him to do it? That's called being careful. What Dr. Quinlivan says is that's completely common sense and appealing and completely incorrect. When there's vague prior familiarity and poor viewing opportunities, the relative judgment enabled by a process of elimination creates a significantly heightened risk of misidentification. It may meet the witness, back to Justice George's earlier question, the witness may believe he's being very careful. He may believe he's looking at the things that he is consciously saying he's looking at. But what we know from the science is that different things are going on below the conscious level, and that's what an expert is there to talk
Familiarity
about.
has kind of a heads I win, tails you lose aspect to it. Because if there's no familiarity, there'd be a point saying that the identification was false, right?
Would there be an argument if you had never seen him before?
Right.
I mean, I suppose there would be.
And then you
I
say,
mean,
well, this familiarity is not good, is poor as well.
well, I mean, the fact that there's a theoretical argument from both directions, I don't think changes the gravity of the argument that's being made here, because I think here is what this court has talked about, the utility of expert testimony when identification issues are counterintuitive. And I think it's quite counterintuitive that prior familiarity can actually be a risk for misidentification rather than an aid.
The old jury instruction didn't
I
cover
certainly
that.
don't think it did, especially because it told the jurors that prior exposure, is something to consider in terms of opportunity to observe. And I
Right,
think
right.
that
I
was
don't
also
think the
quite
old, I
misleading.
don't think the old Rodriguez instruction.
The Rodriguez instruction did, I mean, obviously, this court changed it for many reasons among that.
Right.
So, I see my time is up. If there aren't any further questions, I just ask that the court reverse the defendant's convictions for the barbershop crimes. Thank you.
Thank you. Okay, Attorney Calaflores.
Morning, and may it please the court, Joseph Calaflores for the Commonwealth. In 2015, this court decided Gomes. In 2018, this court once again decided Gomes 2, as well as Commonwealth v. Ayala. I would like to start briefly by addressing the kind of history of the ineffective assistance of counsel, and then I would then proceed to whether or not there are facts within this case for this court on 33E review. Gomes 1 changed the landscape of identification instructions. No one can doubt that. It offered instructions that expanded upon or ultimately changed the Rodriguez instructions. When the defendant went to trial in this matter, the Rodriguez instructions were in full effect. The defendant and the court did not have the benefit of either the SJC's work group on identification, nor the decision in Gomes 1. Therefore, when the defendant trial counsel for the defendant went to trial, he was faced with an ultimate decision, whether or not to retain an expert in identification or proceed with the strong evidence that the defendant did not have cornrows based upon a video taken in the hospital shortly after the crime. Now, without the benefit of the study group or of Gomes 1, counsel cannot be found effective. Gomes 1 and Gomes 2 and Ayala require that. The defendant here is trying to expand a holding from the SJC back to his case and hold not that he was ineffective in requesting or supporting the instructions, but that he was ultimately ineffective for failure to call that witness or to support his argument at the motion to suppress. The Commonwealth urges this court to hold that such practice, such litigation at the time, before Gomes 1 and before the working group, is not ineffective assistance of counsel.
Do you agree that that expert would have been available at that time?
This specific expert, or
An expert who could testify to this material, would they have been available at the time of the trial before Gomes 1 and Gomes 2?
an expert may have been available at that time. The expert that testified here is Dr. Quinlivan, who is, if I'm not mistaken, from a state down south. Dr. Quinlivan is actually cited in the Gomes 1 decision in a footnote and is heavily relied upon for an article that she authored in 2009.
But this evidence, this expert testimony was certainly around. We have the New Jersey cases that.
And the trial court was well aware that it was around. Both trial counsel brought this issue before the trial judge and raised it and requested the New Jersey model instruction. However, the Commonwealth objected that it was a New Jersey case and that it had not been subject to any kind of evidentiary hearing, Daubert-Lanigan, here in the Commonwealth. So that brings me back to the argument that Gomes 1 and 2 are completely applicable here. In Gomes 2, the court stated that we cannot hold counsel to some superhero level of knowing extra jurisdictional cases, especially from New Jersey. And the Commonwealth would argue that to require such a holding would require attorneys to read 50 states and as many jurisdictions to keep minimally aware of what's going on in other areas. Now, the defendant is arguing on appeal that
Well, but wait for a minute. In a murder case, that's pretty serious. Certainly, that's kind of within the scope of the research somebody could do. I mean, it's not that hard, is it?
I agree, it's not that hard. Can't speak to the level of how easily things are searchable on the internet in 2009. In modern times, it certainly is. However, in 2011 to 2013, when they're preparing for this trial, the knowledge is out there. The Commonwealth cannot dispute that. However, we're looking back at whether or not that is ineffective assistance of counsel at that time to a reasonable attorney.
Was this idea that familiarity leads to sort of this transferred identity, was that out there at the time? I haven't seen a lot of those cases, right? I understand the limits of stranger ID, that we've got plenty of cases on that. This idea that, oh, I know the person, therefore I transferred my vision of them onto this person. Was that out there running around at the time too? I mean,
I do not recall right at this moment. The literature that has been developed from then till now is very expansive, so I just can't recall what time frame certain areas of identification theory were developed. I will say that the Rodriguez instructions did instruct the jury to consider familiarity. While it's not as forceful as the modern day instructions, it does instruct the jury to consider it. And while it's a little convoluted on this record, at the motion to suppress, Darrell King, the barber, testified that he knew the defendant from around the neighborhood from his interactions within the community, non-nefarious interactions. He was a coach at the Boys and Girls Club for basketball, and the defendant was always around the facility.
right, but he just escaped from prison and he was infamous at that point, right? Whether he had a neutral reputation before, he's just escaped from prison, 3 or 4 days before this, and he's been on the news, right?
Certainly.
Can you address the cornrow issue and why it's not ineffective when there was available evidence that this characteristic of the shooter could not have been worn by the defendant?
So I think that requires a brief look at this escape. When we're looking at this ineffective assistance of counsel claim, it's manifestly reasonable for trial counsel at that time to try and avoid any reference to his incarceration, his escape.
He could have tried. He could have asked the judge, you know, there's a photograph of the defendant with this woman right after, you know, at a date and time. I mean, he could have tried and get the judge to buy into that.
One of the concerns that trial counsel Andriopoulos had, he testified post-conviction, but Andy Kleiman did not. Andriopoulos testified that one of the concerns, and there are two photographs at issue here, one with Tiara Galbraith and one with Amy Blake. Now, he testified that both of those photos represented issues that would have been present, foremost, whether or not the defendant was incarcerated. Particularly with a photo of Miss Blake, he was specifically concerned that Miss Blake knew certain information both about the defendant, Daryl King, and their relationship. So trial counsel was very aware of certain information that, from the record, it appears that he did not want to come in at trial, which was on top of the fact that he was incarcerated at that time. Given the fact that prior counsel was present at the hospital with an investigator, Mike Chapdelaine, and took a video which clearly showed very short and uncornrowed hairs while sitting in the hospital bed. That is quite strong evidence.
I'm confused by all the different photos. Do you have the record in front of you? Because at 218, is that the booking photo? And then we have the pictures. I assume the hospital photos come a little later, right? Because again, I'm not an expert on cornrows, but is 218 his booking photo, and are the hospital photos at? And then the first pic, 230. We have 218. We have 230 with the defendant and a young woman. And then we have another one later. I just can't separate out all the photos and what we've got in terms of cornrows, because his hair is very short in all of these pictures, right?
So if you're looking at the record appendix, pages 216 through 223, that is the lineup that is shown to Daryl King in the hospital.
Right. And he's at 218, right?
Yes, and 218 is an older photograph.
Okay, that's an older photo. Then we got hospital photos come at a little later, right? Then we have the jail photos are at 253, is that right?
230 and, yes, 253 and 254.
253 and 254. Then we have hospital photos come a little later, right?
Yes.
They're at 255. And you can't see the back of his head, right? And the second photo, I mean, am I able to know that this person doesn't have cornrows from that?
Having some familiarity with cornrows and general hair characteristics,
Well, but that's where
I think it
I'm
would be
going.
possible to make a determination, but it is a poor quality photograph, and I would argue that this is clear, and the video and the proffered enhanced video, it gives you a little more detail, but it just gives you a little bit more detail than this photograph.
And there's expert testimony, at least at the motion for new trial on, or is there? I can't remember. Tell me, how do we know about converting cornrows into non-corn? I mean, do we have testimony on this?
I guess I
Besides
don't.
The barbershop, is the barbershop person at the corrections department the expert? Is that, I'm confused where we are on.
Ms. Talbot testified post-conviction. Ms. Talbot is a certified barber instructor and runs the barbershop program at,
I think it
One
was
of-
Sousa.
I believe so. She runs the program there and basically teaches all of the inmates there on how to give haircuts. She's been a barber instructor for a lengthy amount of time, as well as been cutting hair for equally lengthy amount of time, and is well versed in
Is she the one who
hairstyle.
said the layman point that a layman knows you can't do this, or is that somebody else?
I believe that was her testimony. Now, her testimony, when she is shown the earlier photograph, she says it's hard to tell. When she's shown the later photographs, she says it is either impossible or.
Specific about what photograph she's being shown?
I'm sorry, so the photographs of Miss Blake and Tiara Galbraith, she says it's hard to tell just based on the photograph, but when shown the photograph from the bedside at the hospital, she says it would be impossible or difficult to do that.
To take those cornrows out?
To cornrow
Cornrow
that
that
hair.
hair.
Right.
Which-
There's no testimony in the intervening time if there was any medical intervention in the head that necessitated removing or even paying attention to the head area. So the length of time between the transport to the hospital and that video, there's really nothing that explains.
Do we know when 255 is taken? Is it taken right when he's brought to the hospital, or is 255 taken 5 days later after he could have cut his hair?
My memory is that 255 is a screenshot from a video, which was taken about a few days later, maybe a week later. I don't have that exact date in front of me. I don't know if that's a fair inference that he would have been able to go get a haircut while he's in the hospital, especially after having suffered numerous gunshots in the trunk.
And he's got, is he wounded in his neck? I can't tell what that is in 255.
I'm unsure what that could be. It could be a wound. It could be a PICC line. There's nothing in the record that gives any kind of evidence as to what that white patch is. The defendant, if there are no further questions on the photographs, I'd like to return to some of the case law that
But
is.
the defense attorneys have these photographs, trial counsel have these photographs.
Trial counsel had at least one of these photographs, one of the jailhouse photographs. Tiara Galbraith says that she gave the photograph to him. However, I believe the attorney testified that he does not recall receiving them.
And it's your position that calling these witnesses of the jailhouse photographs were fraught with danger, not only if you could sanitize the fact that he was in custody, but also this motive evidence in
Yes.
these witnesses?
Ms. Galbraith testified that she knew the defendant since they were children. So she has a lot of information about him. Specifically, trial counsel has an issue with Ms. Blake, who has an indeterminate amount of information between the relationship between the defendant
But
and Mr. King.
All right,
Two different females.
witnesses, but one of them doesn't have the motive evidence, or both do?
Ms. Blake has stronger evidence, which is alluded to. However, Ms. Galbraith, who testified at the suppression hearing, Ms. Blake did not testify. Ms. Galbraith testified that she knew him since they were childhood friends. So there's a concern with if she testifies, whether or not she's going to start testifying to any of his involvement that resulted him in going to prison, and as general impeachment evidence as a favorable witness for him.
But don't you think that an effective lawyer could say, Judge, I have this evidence of his hairstyle at the relevant time, and I'd like you to exclude the fact that he was in jail? Because it's more prejudicial than probative. The only issue is what is his hairstyle at a certain date?
I think that would be a fair ask. I
And then
can't
if
dispute
the
that.
judge, and if the judge says no, then you don't call the witness.
I certainly can't dispute that would be one tack for an attorney trying this case to take. However, Attorney Andriopoulos did state on the record that he was immensely concerned with the background information of these two witnesses.
And there was no motion in limine to address this.
I do not believe so. I think the only record evidence we have is that on one of the trial record transcripts, Attorney Andriopoulos is having a discussion with the judge about the Commonwealth contextualizing the photographs.
I mean, what strikes me is, the question is, well, why not? Why not try this evidence? What's the harm? All the judge can do is say, no, I'm not going to allow you to avoid the circumstances of the photograph.
I can't speak to what was going through on trial counsel's mind as to what he imagined the harm would
Well, we
be.
can only base it upon the motion for new trial testimony, right? Or at least for one of the lawyers.
Right. Presenting that type of evidence would certainly have strengthened any argument at that time about the length of hair. However, looking at the photographs of Galbraith and of Blake, it's not a very clear photograph. It doesn't add anything that would not have been shown by the video later on. It's a distant photo, full length, more than full length. I think it's even got some foreground to the photograph. So I don't see any reason to rely upon that to establish a baseline for the later photograph. And the later photograph, as you can see on 255, is much shorter hair.
Well, the witness, I assume, could have been asked, you were with him, a photograph was taken, did he have cornrows?
She could have been asked that question, and she certainly would have answered either yes or no. Ms. Galbraith, at the post-conviction hearing, testified that he was attempting to grow waves, which is sort of a short, cropped haircut according to the record.
How many people identified, I know one of the women in the house said the person had cornrows. Did any of the police officers, the police reports at the time when they arrest him, when they pull him out of the car, any of them describe him as having cornrows? I know at trial some of them testified. Is there contemporaneous evidence that he was described as having cornrows when he was pulled out of the car?
So Patricia Capoza is the officer that counsel referred to that was brought in last minute on rebuttal.
Right.
The trial record shows that she claims she wrote a report. However, there is nothing in the Commonwealth's discovery showing that a report.
Counsel, but didn't the police officer that was shot give a report and say that he had cornrows?
I was about to go there. I don't recall what his report says. In my recent review of the trial transcript, he testifies that the defendant in the trunk had cornrows. On cross-examination, he was not impeached with the absence of any statement about hairstyle within his reports. Hairstyle was not touched upon at all in the cross-examination of Trooper Gregorczyk.
So again, just to summarize that, he testified at trial that the person had cornrows, and we're not sure whether his police report at the time indicated he wasn't cross-examined about its absence, but we don't know what the police report said at the time about whether he had cornrows or not.
On the stand right now, I don't recall what specifically his police report stated, Trooper Gregorczyk.
Because your brother is arguing that there about 8 people lied about cornrows, right? So I'm just trying to get those 8 people, or the number. There are a number of people testifying. There's the woman who reports that the person who runs into the house has cornrows. There's this officer who says cornrows.
I think the position is they're not lying about cornrows.
No, I get it. No, yeah, he's saying they're all lying, but I take it you're saying we got 7 or 8 people saying he has cornrows at the time.
Yes, at trial, on the topic of hairstyle, Trooper Gregorczyk testified, Patricia Capoza testified, and Daryl King testified. Now, and this kind of dovetails into my second area that I want to touch upon, is when we're looking at this case as a whole, and given the context of what ultimately becomes the Gomes 1 instructions of the totality of the circumstances for the identification, we have a near continuous showing of a shooting at the barbershop. 2 percipient witnesses observe one man matching the description fleeing the barbershop and running down the street. Neither of these 2 witnesses describe the haircut, but they describe a man wearing black clothing running down the street. One man saw him go into the barbershop, and then only one man come out the barbershop and begin running down the street. That man was running down the street as well and saw him running down the street. That man goes into a home, and the other man, the defendant, keeps running, and a short time later, he hears gunshots. So we have clear evidence that at the time of the shooting, there was one shooter with 2 weapons. He flees down the street, confirmed by 2 witnesses, and then enters into a home. Now, 2 officers on the street are parked at the corner and observe the motor vehicle pull up and park cockeyed on the street, their language. It then backs into it. Both officers are aware of this house generally and are observing this vehicle because of its mannerisms. They see the defendant get out of the back door, look around up and down the street, and get into the trunk. The car then begins to leave. Those two officers then stop the car.
Was there a shift in the Commonwealth theory about another perp?
Trevin Smith is the only other proffered third-party culprit. He was well known to the Commonwealth, and the defendant argues that a certain statement should have been admitted at trial.
So what about the Commonwealth's closing argument? Did these change horses?
I would argue that it didn't really change courses. It just included a little bit more that was not necessarily addressed earlier.
So what did the Commonwealth say about the third party in the closing argument?
Your Honor, I actually don't recall right offhand. I do know, I did remark to myself that the differences between openings and closings really should not be held against the Commonwealth because evidence evolves throughout the course of trial.
How about Smith in general? So Smith has cornrows, right?
Smith does have cornrows.
He's somehow connected to the defendant. What is his connection to the defendant?
So that morning, I'm not sure what their friendship level is. They are aware of each other and interact. The driver of the motor vehicle testifies that that morning she bumped into Mr. Smith, and he then later arranged for her to go pick something up at the house without telling her what it is.
And where does she bump it? Where does she bump into Mr. Smith earlier?
It's on the street while she is walking. I don't recall the street name off the top of my head. However, it is that morning. So he is generally placed in the area of the shooting in that neighborhood.
And at the time of the barber shop, is there any, are we going to be able to figure out sort of anything about Smith at the time of the barber shop shooting? Because
I don't believe that there's anything in the record about whether or not he stayed in that area. The driver of the vehicle testifies that she was talking to him on the cell phone, and he instructed her to go to the back. Do you have anything in the trunk? Open the trunk. At that point, someone jumps out of the house and gets into the trunk, and they attempt to depart.